Afternoon, everyone. Welcome to the June 2024 GRC Council meeting. We are in the process of letting everyone in and placing them on mute. As soon as we have that all situated, we'll have Chairwoman Berg to back and take the meeting over. And we want to welcome everyone and thank you for being here on this semi-hot day. I'm sure it doesn't rival what we were all dealing with this weekend, but it's summer for certain. So, all right, Chairwoman Berkebacke, when you're ready.
All right. Welcome everybody to the June 25th, 2024 Government Records Council meeting. Please rise for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. This meeting was called pursuant to the provisions of the Open Public Meeting Act. Notices of this meeting, inclusive of call-in information, were faxed to the Newark Star Ledger, Trenton Times, Courier Post of Cherry Hill, the Secretary of State on June 20th, 2024. Members of the public attending the meeting via telephone have been placed on mute by the presenter. At the time that the council arrives at its public comment portion of the meeting, members will be taken off mute and given an opportunity to provide public comment. Please note that the council will strictly adhere to the 5-minute time limit. Additionally, copies of today's meeting agenda can be accessed on the GRC's website at https://www.state.nj.us/grc/meetings/minutes. Proper notice having been given, the secretary is directed to include the statements in the minutes of this meeting. Okay, roll call, please. I can't hear you. Present.
Michael Hunt.
Present.
Emma Lexon.
Present.
Present.
All right, thank you very much. Mr. Executive Director, would you like to give your report?
Sure. Good afternoon, everyone. Happy to see you all on this bright and sunny day. So as always, we'll begin with our current statistics. Since OBRA's inception in July of 2002, the GRC has received 7,105 denial of access complaints, which averages about 323 annual complaints per 22 tracked program years. And again, program years meaning fiscal years, beginning July 1st and ending June 30th. So far in the current program year, which is fiscal year 2024, the GRC has received 320 denial of access complaints. I know, as the council may remember, for the last 2 years, we've received over 500 complaints each year, the last 2 fiscal years. So this year is certainly a step down from that in terms of complaints received at 320, with a couple of days to go here before the end of the fiscal year. All right, so of our 7,105 complaints, 575 remain open, or about 8.1%. Breakdown of where those complaints are out of the process: 11 are currently on appeal with the appellate division, 33 are currently in mediation, 4 complaints are proposed for the Office of Administrative Law, 26 complaints await adjudication by the Office of Administrative Law, 35 complaints are tentatively scheduled for adjudication in an upcoming meeting, which includes today's meeting, and 466 complaints remain work in progress. Since program year 2004, again, fiscal year 2004, the GRC has received and responded to 39,202 total inquiries, averaging about 1,867 annual inquiries per 21 track program years. The GRC did not track inquiries in the agency's first year, so that's obviously the reason for that 1-year discrepancy. So far in the current program year, again, fiscal year 2024, the GRC has received 1,712 inquiries, which is about 7 inquiries per workday. It's actually a little bit over that. So we've been a little bit busier on inquiries from this fiscal year than we were in the last fiscal year. As far as our outreaches are concerned, we don't have anything scheduled for July right now. I don't know if that's going to change. We are receiving a lot of requests based on what I'm about to talk about next. But for right now, we don't have any scheduled outreaches for July. As for that topic I'm about to speak about, it relates to follow-up to our last meeting where I talked about S2930. which was the pending Oprah legislation. On June 5th, 2024, Governor Murphy did sign that legislation into law as PL 2024, Chapter 16. It has a 90-day delayed enactment, so it will go into effect on September 3rd, 2024. Obviously right now, we're eyeing several projects requiring attention based on the new version of the statute. We're working through them to make sure that we're prepared for the statute's enactment on September 3rd, and really what will come after. Of immediate import for the GRC and the council, regarding the GRC, we will be required by statute to adjudicate complaints within 90 days after receipt, barring a 45-day extension with good cause having been shown, 18 months after the enactment of the date. So from September 3rd, we'll have 18 months to get to a position where we're adjudicating complaints within 90 days of receipt. I'll note that doesn't include any time spent mediation should the complaint be there, but that obviously is going to impose on us this time frame to adjudicate these complaints. As for the council, there will be some significant changes. Most significant is that the council will expand to 8 appointed members. So first thing that will have to happen is that they'll have to be appointed, and they will receive compensation commensurate with the local finance board appointees, which is definitely new from the current version of the statute. So we'll have to see what happens with the 8 appointments. DCA's commissioner or their designee will become the chair, and the DOE commissioner will no longer serve as a member of the council. So we have these moving parts. Mr. Alexi, obviously that would put you, if the law were in effect today, currently as chair, and Mr. Hahn, obviously you would not be with us unless you were interested in attending as a member of the public. So that's the big, that would be the big change for the council. We expect these changes are going to occur for the September meeting. So right now, we don't expect to see any changes for the July and August meeting. So we'll continue in this format through then. But that's obviously a significant change here in the next few months. There may be some parting of the ways after many years together. So obviously the statute will change significantly, and it may be, maybe time for time to say goodbye, unfortunately, depending on what happens. So that's where we're at. That's my report. As things become clear, obviously, I'll be updating the council throughout the process. And that is my report for today.
All right, thank you very much, Mr. Caruso. We do not have a closed session today, so we will move right into approval of the minutes of the last meeting. Is there any discussion on the May 21st, 2024 open session meeting minutes? Hearing none. I have a motion to approve, please.
So moved. Second.
Reverend Betzalowski,
Yes.
Michael Hahn,
Yes.
Don Alexi,
Yes.
Darrell Thomas.
Yes.
All right, we move into new business. Case is scheduled for consent agenda administrative complaint disposition adjudication. An administrative complaint disposition means a decision by the council as to whether to accept or reject the executive director's recommendation of dismissal based on jurisdictional, procedural, or other defects of the complaint. The executive director's recommended reason for the administrative disposition is under each complaint below. And now we move into administrative disposition adjudications with recusals. Mr. Vittardi is recused from this, and so he is not able to vote. Tyshawn Feaster v. Essex County Correctional Facility 2022-30. No correspondence received by the custodian. Could I have a motion to accept this, please?
Moved. Second.
Reverend Betzalowski,
Yes.
Michael Hahn,
Yes.
Don Alexi.
Yes.
Okay, the next 2 administrative disposition adjudications have no recusals. So Mr. Vittardi is able to vote. We'll take these together. Kevin Alexander v. Middlesex County Board of Chosen Freeholders 2024-100. duplicate complaint filed with the GRC. Kevin Alexander v. Middlesex County Board of Chosen Freeholders 2024-119. No records responsive to the request exists. Is there any discussion? Hearing none, motion please to accept.
So moved.
Second.
Rodney Berzalaki.
Yes.
Michael Hahn.
Yes.
John Lancy.
Yes.
Rivera Sadi.
yes,
All right, thank you. So we move into administrative disposition, uncontested voluntary withdrawals by complainant. There is no adjudication by the council required, but I will read through them. Laura Meckler v. South Orange and Maplewood School District, Essex, 2022-657, complaint voluntarily withdrawn. Paul Marinaccio v. Borough of North Plainfield, Somerset, 2023-178, complaint voluntarily withdrawn. Richard La Barbiera, Esquire, on behalf of Sharon DeLucia v. Borough of Leonia, Bergen, 2024-17, complaint voluntarily withdrawn. Christian Guerrero v. New Jersey Department of Health, 2024-27, complaint settled in mediation. Maureen Chandra v. City of Jersey City, Hudson, 2024-28, complaint settled in mediation. Jacques Gear III v. West Long Branch Fire Company, number 2, Monmouth, 2024-45, complaint voluntarily withdrawn. Michael Maselli, on behalf of Lyft Inc. v. Township of Willingboro, Burlington, 2024-106, complaint voluntarily withdrawn. Paul L. Trachtenberg v. New Jersey Department of Education, 2024-112, complaint voluntarily withdrawn. Laura Mistretta v. City of Jersey City, Hudson, 2024-123, complaint voluntarily withdrawn. Chelsea Van Dellen v. Fairlawn Board of Education, Bergen, 2024-135, complaint voluntarily withdrawn. Now we move into new business, cases scheduled for consent agenda administrative order. An administrative order means an order issued by the council requiring the records custodian or the complainant to perform a specific action in furtherance of the adjudication of a pending denial of access complaint or taking other actions deemed appropriate to adjudicate a complaint in an expedited manner. The executive director's recommended reason for the administrative complaint is under each complaint below. There are no administrative orders with recusals, and there is one administrative order with no recusals. Akash Dalal v. New Jersey Department of Law and Public Safety, Division of Criminal Justice, 2022-55 for an in-camera review. This is a consent agenda, so could I have a motion to approve, please?
So moved.
Second.
Rodney Berzalaki.
Yes.
Michael Hahn.
Yes.
John Lancy.
Yes.
Rivera Sadi.
yes,
Thank you. We move into new business cases scheduled for an individual complaint adjudication. The executive director's recommended action is under each complaint below. We have 4 recusals. Mr. Riccardi is recused from the first 4 cases. So please mute. Thank you. Stephen Schnitzer, Esquire, on behalf of Vito's Trattoria, Inc., v. New Jersey Transit, 2016-140.
The current custodian complied with the council's April 30th, 2024 interim order. There is no knowing and willful violation. The complainant is a prevailing party. The party shall confer on fees and advise the GRC within 20 business days if an agreement is reached. If not, complainant's counsel shall submit a fee application in accordance with NJAC 5:105-2.13.
Thank you. Is there any discussion? Hearing none, motion, please.
So moved.
Second.
Berzalaki.
Yes.
Michael Hahn.
Yes.
John Lancy.
Yes.
Art Rittenhouse Jr. v. Borough of Sayreville, Middlesex, 2021-33.
The council should accept the administrative law judge's June 6, 2024 initial decision approving the settlement agreement and mutual release and ordering the parties to comply with the terms thereof.
Thank you. Is there any discussion? Hearing none, motion, please.
So moved.
Second.
Edward Salaki,
Yes.
Michael Hart,
Yes.
John Alexi,
Yes.
Maria Diamante v. Rutgers University, 2022-25.
The custodian's failure to timely respond resulted in a deemed denial of access, NJSA 47:1A-5G and 5I. The custodian's failure to respond immediately to Oprah request item number 4 resulted in a violation of Oprah, NJSA 47:1A-5E, and Heron v. Township of Montclair, GRC complaint number 2006-178, February of 2007. The custodian's response was insufficient because she failed to address each Oprah request item individually, NJSA 47:1A-5G, and Path v. Willingboro Board of Education, Burlington, GRC complaint number 2007-272, May of 2008. The custodian did not unlawfully deny access to the complainant's Oprah request item numbers 1, 2, and 4 because all records were disclosed. Danis v. Garfield Board of Education, Bergen, GRC complaint number 2009-156 ed sec, interim order dated April 28, 2010. The custodian lawfully denied access to the letters of reference responsive to the complainant's Oprah request item number 3 under the privacy interest exemption, NJSA 47:1A-1, and Burnett v. County of Bergen, 198 NJ 408-2009, as well as Reynolds v. New Jersey Board of Public Utilities, GRC complaint number 2008-14, August of 2009.
Thank
Yep.
you. Is there any discussion? Hearing none, motion, please.
So moved.
Second.
Edward Salaki,
Yes.
Michael Hart,
Yes.
John Alexi,
Yes.
Stacy Purcell v. City of Bayonne, Hudson, 2022-584.
The custodian timely responded in writing immediately. As such, no deemed denial occurred. NJSA 47:1A-5E, and Rainello v. City of Trenton Mercer, GRC complaint number 2017-222, July of 2019. The custodian's failure to respond within the extended time frame resulted in a deemed denial of access, NJSA 47:1A-5G and 5I, and Cohen v. Township of Livingston Library, Essex, GRC complaint number 2007-124, March of 2008. However, the GRC declines to order disclosure because the custodian did so on September 14th, 2022, and there is no knowing and willful violation.
Thank you. Is there any discussion? Hearing none, motion, please.
So moved.
Second.
Edward Salaki,
Yes.
Michael Hart,
Yes.
John Alexi,
Yes.
All right. Thank you very much. There are no recusals for the next for the rest of the cases. So Mr. Retardi can unmute. Thank you. Lisa Andrula Porto v. Cape May County, 2020-62.
The council should reject the custodian council's request for reconsideration based on a mistake. However, the council should suspend the February 27, 2024 administrative order pending a response to additional information. To the extent that the custodian disclosed records in hard copy for the appropriate per page cost, no violation of Oprah occurred and no refund is warranted, NJSA 47:1A-5B. Further, the custodian was not required to waive or disclose additional hard copy records absent receipt of payment. Reed v. GRC and NJ Department of Corrections, Unpub, Lexus, 2625, Active 2023. And Path v. City of Plainfield, GRC complaint number 2006-54, July of 2006. The custodian unlawfully denied access to the responsive emails and attachments where applicable and must disclose same in the meaningful medium of a PDF, NJSA 47:1A-5D. The knowing and willful analysis is deferred.
Thank you. Is there any discussion? Hearing none, motion, please.
So moved.
Second.
Edward Salaki,
Yes.
Michael Hart,
Yes.
John Alexi,
Yes.
Edward Retardi,
Yes.
Thank you. Rotimi Oa Esquire, on behalf of Dolores Simmons, Obafemi Simmons, and Grace Wilco, the Park Ridge Police Department, Bergen, 2021-142.
The custodian unlawfully denied access to the responsive records, NJSA 47:18-6, and Simmons v. Mercado 247 NJ 2442 2021. However, the GRC declines to order disclosure because the custodian did so on March 21st, 2021. The complainant is a prevailing party. The party shall confer on fees and advise the GRC within 20 business days if an agreement is reached. If not, complainants counsel shall submit a fee application in accordance with NJAC 5:105-2.13.
Thank you. Is there any discussion? Hearing none, motion please.
So moved.
Second.
Member Kubaki.
Yes.
Abraham.
Yes.
John Alexi.
Yes.
Mayor Taylor.
Yes.
Rotimi Oa Esquire, on behalf of African American Data and Research Institute, Baffy Simmons and Dolores Simmons, the Borough of Leonia, Bergen, 2021-242.
The custodian's response was insufficient because she failed to address each OPA request item individually, 47:1A-5G and PATH GRC 2007-272. The custodian unlawfully denied access to the requested disclosable personnel information and must disclose the most comprehensive record containing same, 47:1A-10, Danis GRC 2009-156, Valdez v. Union City Board of Education, Hudson, GRC complaint number 2011-64, interim order dated August 28th, 2012, and Matthews v. City of Atlantic City, Atlantic, GRC complaint number 2008-123, February of 2009. The custodian lawfully denied access to the portion of the complainant's OPA request seeking agreements because she certified, and the record reflects, that no records exist. Pusterhofer, the NJ Department of Education, GRC complaint number 2005-49, July of 2005. The prevailing party analysis is deferred.
Thank you. Is there any discussion? Hearing none, motion please.
So moved.
Second.
Member Kubaki.
Yes.
Abraham.
Yes.
John Alexi.
Yes.
Mayor Taylor.
Yes.
Tucker M. Kelly v. Rockaway Township, Morris, 2021-359.
The custodian's failure to timely respond resulted in a deemed denial of access, 47:1A-5G and 5I. The custodian lawfully denied access to the responsive dash cam footage, which was part of an internal affairs investigation, 47:1A-6, 47:1A-9A, the internal affairs policies and procedures, as well as Rivera v. Union County Prosecutor's Office, 250 NJ 124, 142, and 143 from 2022. The complainant is not a prevailing party.
Thank you. Is there any discussion? Hearing none, motion please.
So moved.
Second.
Kubaki.
Yes.
Abraham.
Yes.
John Alexi.
Yes.
Mayor Taylor.
Yes.
Tucker M. Kelly v. Rockaway Township, Morris, 2022-36.
You're muted.
Yep, Madam Chair, just wanted to note that the FR has been modified to include an analysis on the prevailing party that was not included in the original submissions.
Thank you.
So that analysis has been added.
All right, I'll read the conclusions with that additional amendment. The custodian's extensions were unwarranted and unsubstantiated. Thus, a deemed denial of access occurred. 47:1A-5G, 5I, and Cicerone v. New Jersey Department of Treasury, GRC complaint number 2013-280, interim order dated July 29, 2014. However, the council should decline to order disclosure of the responsive records because same were provided on March 4th, 2022. There is no knowing and willful violation, and the complainant is not a prevailing party.
Thank you. Is there any discussion? Hearing none, motion please.
So moved.
Second.
Elizabeth Sabaki,
Yes.
Michael Hart,
Yes.
John Alexi,
Yes.
Gerald Fry,
Yes.
Rotimi Owa Esquire on behalf of African American Data and Research Institute, the Galloway Township Police Department, Atlantic, 2022-46.
The custodian's response was insufficient because she failed to address each OPA request item individually, 47:1A-5G and PAF GRC 2007-272. The custodian performed an insufficient search to locate records responsive to the requested personnel information at 47:1A-6, Sneebel v. New Jersey Department of Environmental Protection, GRC complaint number 2007-220, April of 2008. However, the GRC declines to order disclosure because the custodian did so as part of the statement of information. The custodian lawfully denied access to the portion of the complainant's OPA request seeking agreements because she certified and the record reflects that no records exist. Pusterhofer, GRC 2005-49. The complainant is a prevailing party. The party shall confer on fees and advise the GRC within 20 business days if an agreement is reached. If not, complainant's counsel shall submit a fee application in accordance with NJAC 5:105-2.13.
Thank you. Is there any discussion? Hearing none, motion please.
So moved.
Second.
Elizabeth Sabaki,
Yes.
Michael Hart,
Yes.
John Alexi,
Yes.
Gerald Fry,
Yes.
Rotimi OO Esquire on behalf of African American Data and Research Institute, the Atlantic City Police Department, Atlantic, 2022-47.
The custodian's response was insufficient because she failed to address each OPA request item individually, 47:1A-5G and PAF GRC 2007-272. The custodian did not unlawfully deny access to the portion of the complainant's OPA request seeking disclosable personnel information because all was disclosed. Danish GRC 2009-156 ed sec. Custodian lawfully denied access to the portion of the complainant's OPA request seeking agreements because she certified and the record reflects that no records exist. Pusterhofer, GRC 2005-49. The complainant is not a prevailing party.
Thank you. Is there any discussion? Hearing none, motion please.
So moved.
Second.
Elizabeth Sabaki,
Yes.
Michael Hart,
Yes.
John Alexi,
Yes.
Gerald Fry,
Yes.
Andrew Garcia Phillips v. City of Rahway Union, 2022-59.
The custodian's failure to respond within the extended time frame resulted in a deemed denial of access, 47:1A-5G and 5I, and Cone GRC 2007-124. The custodian's failure to respond immediately to OPA request item numbers 1 and 4 resulted in a violation of OPRA 47:1A-5E and Heron GRC 2006-178. The custodian did not unlawfully deny access to records responsive to OPA request item numbers 1 and 4 because he disclosed them on March 8th, 2022. Matthews, GRC 2008-123. Further, the current custodian cured a technical issue with the disclosed record once made aware of the issue. The custodian lawfully denied access to OPA request item numbers 2, 3, and 5 because he certified and the record reflects that no records exist. Pusterhofer, GRC 2005-49. And there is no knowing and willful violation.
Thank you. Is there any discussion? Hearing none, motion please.
So moved.
Second.
Elizabeth Sabaki,
Yes.
Michael Hart,
Yes.
John Alexi,
Yes.
Gerald Fry,
Yes.
Don Bellocchio v. Middlesex County Prosecutor's Office, 2022-60.
The request seeking any and all criminal records was invalid because it failed to specify records and required research. MAG Entertainment LLC v. Division of Alcoholic Beverage Control, 375 NJ Super 534, 546, Active 2005. Ben v. Stafford Police Department, 381 NJ Super 3037, Active 2005. Thus, the custodian lawfully denied access to the subject request, 47:1A-6.
Thank you. Is there any discussion? Hearing none, motion, please.
So moved.
Second.
Rebecca Larkin,
Yes.
Michael Hone,
Yes.
John Alexi,
Yes.
Sarah Taddy,
Yes.
Matthew Strieger Esquire on behalf of Lincoln Park EMS, the NJ Department of Health, 2022-299.
The custodian lawfully denied access to the subject open request on the basis that it would substantially disrupt agency operations, 47:1A-5G and 6, as well as Karakashian v. New Jersey Department of Law and Public Safety, Division of Consumer Affairs, Office Board of Medical Examiners, GRC complaint number 2013-121, EdSec, November of 2013. The complainant is not a prevailing party.
Thank you. Is there any discussion? Hearing none, motion, please.
So moved.
Second.
Rebecca Larkin,
Yes.
Michael Hone,
Yes.
John Alexi,
Yes.
Sarah Taddy,
Yes.
Mark Liebeskind v. New Jersey Department of Transportation, 2022-569.
The custodian's failure to timely respond resulted in a deemed denial of access, 47:1A-5G and 5I.
Is there any discussion? Hearing none, motion, please.
So moved.
Second.
Rebecca Larkin,
Yes.
Michael Hone,
Yes.
John Alexi,
Yes.
Sarah Taddy,
Yes.
James M. Jenna v. Borough of Victory Gardens, Morris, 2023-42.
The custodian's failure to timely respond resulted in a deemed denial of access, 47:1A-5G and 5I. C. Dietrich v. City of Hoboken, GRC complaint number 2008-4, March of 2009. The custodian unlawfully denied access to the responsive meeting recording and must disclose same, 47:1A-6, and Burlett v. Monmouth County Board of Chosen Freeholders, GRC complaint number 2009-49, February of 2010.
Thank you. Is there any discussion? Hearing none, motion, please.
So moved.
Second.
Rebecca Larkin,
Yes.
Michael Hone,
Yes.
John Alexi,
Yes.
Sarah Taddy,
Yes.
All right. Thank you very much. There are no court decisions of GRC complaints on appeal or complaints adjudicated in New Jersey Superior Court and New Jersey Supreme Court, or complaints adjudicated in U.S. District Court. So we move into public comment. The public comment period is limited to providing an opportunity for speakers to present suggestions, views, and comments relevant to the council's functions and responsibilities. In the interest of time, speakers will be limited to 5 minutes. Speakers shall not be permitted to make oral or written testimony regarding pending or scheduled adjudications. Would anyone like to make a public comment?
All right, so for our attendees today, if you are interested in making a public comment at this time, you will want to press *6 on your telephone, *6 if we see you unmute. We'll just ask for your name and then you can give your public comment. Again, *6. We usually give folks about 30 seconds here to determine whether or not they would be interested in providing a public comment. Again, *6 is the way you unmute yourself to give public comment. About another 15 seconds there. *6 if you're interested in unmuting and giving public comment. In about another 10 seconds, again, *6 for any of our interested attendees. We'd certainly welcome any comments if you had them at this time. About another 5 seconds for *6. Going once, twice. All right, Chair, it looks like we have no public comments from the meeting this month.
All right, thank you very much. I will entertain a motion to adjourn, please.
So moved.
Second.
Rebecca Larkin,
Yes.
Michael Hone,
Yes.
John Alexi,
Yes.
Sarah Taddy.
Yes.
All right, thank you very much. We are adjourned. see everybody next month at the July meeting. Have a great
right.
summer.
Same to you all. Appreciate it. Have a good one.
Take care, everyone.
Stay
Okay,
cool.
So moved.
Bye-bye.
Bye-bye.
Bye-bye.